Hey, it's Jack from Jackie the Real Estate and the Online Real Estate Academy. So, August 17th, the date of implementation for the National Association of Realtors court settlement is coming up just in a couple of weeks. And I thought it would be good to step back a little bit for this video for the benefit of there's a lot of agents out there that are not really getting the support from their broker and don't really know what's happening. Although you should consult with your broker. And there's a lot of members of the general public, consumers, buyers and sellers, who heard about something maybe this past spring, but since then they haven't really heard of what's going on. And so we're going to just bring it back to basics, so to speak, in this video, a tutorial, if you will, to figure out what the old system was and what the new system is going to be, generally speaking. So we're going to do this with the chalkboard, which we'll bring out in just a second, and we'll do it in two parts. Again, old and new. Let's cut to the chalkboard to understand the old system, and through that, we can understand where we're going with the new system. All right, chalkboard. Okay, under the old system, which was determined to be an antitrust violation in this massive court case that got decided in October of 2023, where the National Association of Realtors, I should probably mention I'm not a member, but I am a licensed broker, and all of the big real estate companies, or almost all, basically big real estate, they were found to be in violation of the Sherman Antitrust Act for inflating buyer side fees under the old system. And that's why we're here to talk about what the new system is going to be. So this was considered to be an antitrust violation according to the big court case. And this is how it worked. You basically had four parties involved here: the seller, the buyer, the seller agent, and the buyer agent. And the important part to understand, and we're going to draw some lines on this in just a second, is that effectively, under the old system, the buyer and the buyer agent were not involved in setting the fee that the buyer agent received. How did that work, Jack? Well, let me show you. The seller and the seller agent would have a listing agreement. And this listing agreement determined the total amount of compensation that the seller was going to pay when their house sold to the seller agency. Let's just say 5%. But this listing agreement also determined how much of that 5% was going to be shared with the buyer agent. So the buyer agent's compensation was established through an agreement between the seller and the seller's agent. The buyer wasn't involved at all, really, in determining how much their agent would make on the transaction. And how would the buyer agent find out about how much they might get paid? How would they find that out? Because it was posted in the multiple listing service, the MLS, which is a large number of services, actually like 500 of these across the country. You just know it as like one MLS. It's actually, no, it's like a whole balkanized system of these little fiefdoms. But aside from that, it would be published in the MLS how much the buyer agent was going to get paid, in this case 2.5%, and that was determined by the written listing agreement between the seller and the seller agent. Buyer not involved. And the court case said that this scheme, if you want to call it that, or this format, or this way of doing business, inflated buyer commissions because a lot of buyers had no idea what their agent was getting paid. In fact, some buyer agents even told their buyer clients that, oh no, it's free, which obviously isn't true, because when you buy a property, where does the money come from? It comes from the buyer and or their lender, right? And so the buyer is bringing all of the money to the table, every last penny, and the buyer agent is making something, obviously that money is coming out of the buyer's pot that the buyer is sliding into the table, right? So effectively, the buyer does pay the buyer's agent. It's not free, but it was predetermined by the listing contract. Oh, yeah, that means kind of the buyer's kind of flying blind a little bit here. Uh-huh. And it also meant that the buyer was paying this buyer's agent regardless of whether the quality of the representation was what it should be or what it was not supposed to be, right? And there was no discussion about, hey, what are you going to do for this 2.5% or 3% or whatever it was going to be, right? It was just this number set by somebody else. There was no discussion between the buyer and the buyer's agent as to the services or the quality that would be offered and delivered. And without that discussion, then there's really no friction, I should say, about how much it's going to cost. Because effectively, unless you as a buyer looked at the settlement statement, which very few buyers look at, very few sellers look at, unless you kind of look down the settlement, you really probably don't even know how much your agent made. It was just like, they made some money. Oh. And that's how the vast majority of people bought and sold houses. They really didn't know, especially they didn't know how much their buyer agent was getting paid, which meant that price of that service was inflated. Because there was never a point where the buyer the buyer agent had to have a difficult discussion or a frank discussion or whatever euphemism you want to use with their client and justify their fee. There was never a point where they had to justify and establish why you're paying me 2.5%. There was never that awkward, that didn't happen, and therefore people got paid, which they may or may not have earned that whole amount. Okay, so in the springtime of this year, the National Association of Realtors came out with the plaintiff's lawyers after the guilty verdict last fall and came up with this settlement. And this settlement is going to apply across the country in most cases, but not all cases. So let's get to the settlement and what the settlement says. Now, it's important to note, as I just said a few minutes ago, this settlement is not universal, and it's going to depend upon your local state laws, and it's also going to depend upon whether or not your agent is a realtor or not, and or if the MLS that your agent is a member of opted into the settlement. So there's a couple of things that you'll have to check to see if it really applies to you as an agent and or you as a buyer or seller. But overall, the vast majority of transactions will be handled like this. A quick note. Remember, I'm not an attorney, so this is just entertainment advice. You should go seek your own legal advice. And also, as I mentioned earlier, I'm not a realtor. I'm a licensed real estate broker here in Massachusetts, but not a realtor. And also, my MLS opted out of the settlement. So our office doesn't have to comply with the settlement, and we'll comply with some of the things, but not the other. It can get confusing, so you should, especially if you're an agent, double check with your broker. All right, back to the chalkboard. All right, so one of the big things about the NAR settlement is that if it applies to you, you're going to have to enter into an agreement between the buyer and the buyer agent just to see a house. I know. So if you call up your agent and your agent says, hey, 123 Main Street came on the property on the market the other day. Would you like me to set up a showing? And this is the first time you've seen a property. Maybe it's the first house you've seen. And you say, yes, I want to see it. Understand, they're also going to send you over an agreement because they can't show you that house without having a buyer agency agreement in place under the NAR settlement. That buyer agent agreement also, we should note, should include a discussion about the fee, and it should cap the fee. In other words, let's just say if it's 2.5%, 2.5%, there should be a provision in there to make sure that they don't get paid any more than that 2.5%. For instance, if the seller wants to throw in another 1% on top of that, for instance, no, that would be verboten. No, can't do that. So this is a new thing for the vast majority of agents in the country. Again, doesn't apply to my agency, but that's for a different video. But for most of you, you're going to have to enter into this buyer agreement just to see a house. There's a lot of implications for that. Not enough to go into this basic tutorial, but that's a very important difference. And theoretically, that is supposed to force the discussion between the buyer and the buyer agent as to the value of the services of the buyer agent. And theoretically, that should drive down the price that the buyer agent gets paid, which would save consumers money. That's the thinking. Now, on the flip side, the seller will still have a listing agreement with the seller agency. This is where things kind of get a little bit confusing. In regards to the compensation, you can still offer compensation from the seller agent to the buyer agent, but you can't do it on the MLS. Let me just draw that out on the chalkboard here. So there can still be a traditional listing agreement, let's just say 5%, and it says 2.5% of that is going to go to the buyer agent, but they cannot communicate that information on the MLS. Cannot use the MLS to communicate that. So they're going to have to come up with some other method, whether it's text message or phone call or whatever, but you can't do it on the MLS. But under the NAR settlement, it's still allowed. But the Department of Justice is also kind of frowned upon that a little bit. And I think there's a lot of pressure to come up with this other alternative that kind of makes things a little bit cleaner, if I may. Cuts out the middleman, so to speak. And that would be a listing agreement between the seller and the seller agent, for instance, and then the seller pays the buyer agent directly without the money throwing. The money does no longer flows through the seller agent. The seller pays the buyer agent directly at closing based upon a request to get paid that would be written in the offer. And that request to get paid that's written in the offer, that can be written up as a seller concession, which we'll just abbreviate as CON, or it can be more like a direct payment. There's a number of pluses and minuses. We're not going to get into the details on that. But effectively, the payment directly comes from the seller to the buyer's agent. And once again, there would be a requirement to have a buyer agency agreement. That doesn't change. So this is, I think, this is going to become more commonplace. Well, you know, who knows? But this is also allowable, as is the other one that we just talked about, as long as you don't do it on the MLS. If you're going to have the seller agency pay the buyer agency, you cannot use the MLS to facilitate the transfer of that information, so to speak. Is this going to make any difference? Are buyer agency fees going to come down just because basically we're having this discussion off of the MLS and the seller's paying the buyer agency directly? I don't know. I'm not too sure. Nobody knows for sure, actually. The fact that the buyer is going to have a discussion with the buyer agent as to the services and the fee, that's probably really healthy for the marketplace. I'm a big in favor of that. But keep in mind, there are some jurisdictions, Colorado, for instance, where they can't force you into a contract. And I really can't put my thumb on it, but there is something about the mandating of a contract, which, gee, I really can't elucidate it, but it makes me suspicious. Whenever I don't like mandates, generally speaking, and it seems like almost like a backdoor way to keep the current system. Maybe deeper thoughts with Jack Gately on that in a different video. But the fact that the buyer and the buyer agent are going to have this discussion is probably a healthy step in the right direction. I'm not too sure I like the mandate, but there it is. Just to throw it out there, there was this other alternative proposal that was, how do I want to say this, stricter. And that would draw a line between both sides and effectively completely decouple commissions so that the seller would pay the seller agent and the buyer would pay the buyer agent. That's still doable. It's allowable, but there were some people who wanted to make this the rule, and that didn't happen. So it's still allowable that the seller pays the buyer agent, and it's still allowable off MLS that the seller agency pays the buyer agent. But there were some people that wanted a complete decoupling of commissions. That did not happen. Okay, so I hope that brings you up to date with the old and the new. And I would just say that as we move into this new system, there are no perfect outcomes. There is no perfect world. It's just going to be different. I hope it's better. And I think it is better overall. I think it could have been better or I think it could have been better. But it's better than the old thing for sure. And we still have some more progress to make, I think. But there is no perfect world, and there are definitely downsides to the new system, which we've mentioned before in other videos and we'll mention again. But I just wanted to pass along the accounting for you in this basic tutorial video. All right, thanks for watching. I'm Jack from Jack Gately Real Estate and the Online Real Estate Academy. Have a great day.